I think that's fine.
Okay, well, welcome. My name is Philip Leach. I'm Professor of Human Rights Law here at the Law School and Director of the European Human Rights Advocacy Centre, which is the centre I've talked to a number of you about before, which is the Centre doing human rights cases. Welcome to our students over there from Mauritius. You're very welcome. The session today is looking at the right to life, and particularly the right to life in the context of custody, prison custody. And I want to talk, especially been asked to talk really especially about the problem of self-inflicted death of people in prison. And one of the reasons for that is that I'm currently a member of this review, the Harris Review, which is a review that's set up a year ago. We're just about to report. It was set up by the Prisons Minister about a year ago, so looking at the deaths of young people in prison in England and Wales, and looking at the particular problem of self-inflicted deaths. Okay. Now we're a group of about 10 of us all together, looking at this issue because there's been a rise in just in the last few years of young people, 18 to 24-year-olds, killing themselves in prison custody. Okay. And chaired by Lord Harris, we've had a year to try and look at the issues and try and make some recommendations. And we're in the last frantic period now because we've got a report by the end of March. So we've got to gather all our evidence. We've been hearing evidence. We've been having hearings. We've been having people from government, people from NGOs, members of families of people who killed themselves in prison come and give evidence to us, and we've recorded that evidence, and we've had a whole series of other meetings. We've had written submissions. We've been to prisons quite a lot. We've been to prisons, young offender institutions, and so on around the country to try and see for ourselves what the problems are. And you can imagine that there are quite a lot of them. Keep out of the range of the camera. So that's the Harris Review, and we are a group. My background is law, human rights law. There is a forensic pathologist on the team. There is the director of Inquest, which is, if you know, is an NGO which supports families who are going through inquests, which is the way, this is how deaths in custody are investigated in this country. And there's also the head of Metropolitan Police sort of medical service, so he's a doctor, and there's a prison psychiatrist. So there's a group of people with a range of different experience and different input to give. And we're trying to come up with some recommendations. And I'll say a little bit, I'll come back to that. I'll say a little bit more about that in a moment. But what I wanted to go back to is to go back to the human rights principles that you've already seen and looked at, and just try and underscore those, and perhaps try and discuss with you what they mean. And you remember from, when was it, earlier this week or last week, Alice? Last week. You talked about Article 2. I mean, I've talked about to one or two of you about Article 2 in the past. So this is Article 2 of the European Convention on Human Rights, which is applicable here, as you all know, because of the Human Rights Act. The Human Rights Act that brought the European Convention into the law here. And don't get confused between the two. The Human Rights Act is the mechanism for incorporating the Convention rights, and it's the Convention rights. And this is one of the Convention rights that is applicable. This is the right to life. So I put that back up. I'm about to ask you some questions about it to see if you understand this. If you have a problem like people killing themselves in custody, how do you get from that, which is the text of Article 2? How could you say that the state might be liable in the law under Article 2 where there's where someone kills themselves? So I'm just trying to ask you how you understand, what you understand from the right to life. Yeah, thank you.
Look, then, if they give you a hard time in prison, let's say they don't feed you properly, or they beat you up too much or something,
yeah.
It might drive you to want to commit suicide, they might even kill you.
Okay.
They just want to treat you well.
Okay. So, well, yeah, so there are some examples. So they might even kill you, say. So you've got some example. That's a, quite a stark example where it's very clear from that, sort of that second sentence there, no one should be deprived of their life intentionally, save in particular circumstances. So you've got, that would cover the situation where the state, takes your life. You get beaten up or something and you die. But what about turning it around to those other situations, and the situation of how do you get from this to any kind of liability for the state to have to do something? Why do I stand here, and Alice stood here before you last week, saying the state does have a liability in some situations, or it might do when somebody kills themselves? Yeah.
Could that be because of their failure to act or omissions?
Yeah.
In certain cases.
Exactly. Failure to act or omissions is exactly. How do you get that from the law? I'm just asking you to also to look at the law here. Why do you say why does that matter? There's a failure to act.
Because you have a duty of care.
Why do you have a duty of care?
Because they're in your institution.
Okay. And just from this, where's the bit that's relevant here? Because what you're saying is right. Where's the bit that's relevant to having a positive duty of care?
This is life is protected by law.
Right. That first sentence, everyone's right to be protected by law. Absolutely. That's the bit that all we're going to discuss today hangs on. It's very general, isn't it? Everyone's right life to be protected by law. Because the rest of this is negative in the sense of it's telling the state you can't do something. You can't deprive life intentionally in other than in certain circumstances. You can't, it's negative, don't kill people. But what we're talking about here is a positive of it. You've got to actually do something, as you said. If there are omissions, you've got to do something, as you said. And that's this first sentence. Everyone's right to life shall be protected by law. Now, there's no detail in that. How do you know what the obligations are? How do you know if there's an omission? Because it's very, very general. So where do you go from here, from that sentence to work out? How do we know what that sentence means? How is it applied?
Well, the part that says everyone's right, basically, from my understanding, is regardless of your race, your background, age, ethnicity, regardless of who you are, you have to be protected and you have to be given certain rights.
Yeah.
No matter what you've done or been accused of doing.
Yeah. Yeah, absolutely right. I mean, that's a fundamental point about prisoners. Their punishment is that their loss of liberty. Is their punishment anything else? Politicians have expressed different views on that sometimes, but in terms of human rights law, the punishment is the loss of liberty. Okay, and where, if you were being very diligent and wanting to look up what this means, where would you go to try and find out what that means in practice? If this is Article 2 of the European Convention on Human Rights, just where practically would you look?
Case law.
You look at the case law of what?
From the European Court.
From the European Court, yeah, and also, of course, the UK courts, because the UK courts is applying this stuff since, under the Human Rights Act, since October 2000. It's not that old, in fact. It's only since. So, European Court and the UK courts, absolutely. And just to we'll go on to another couple of slides, but just to underline again, you've got negative obligations and you've got positive obligations from this. Negative obligations, don't kill. Positive obligations, you've got to protect life. What that means, we'll just come on to in a moment. So just, I'm jumping ahead through the slides you've already looked at, but just to remind you, some examples of positive obligations. Two cases, these are both European Court cases. LCB against the UK and Makaratsis in Greece. An LCB, a positive obligation for states to take appropriate steps to safeguard the lives of those within their jurisdiction. Okay, now I'm going to come on in a moment I'm going to sort of focus in gradually to think about position of people in custody and people who take their life, their own life, and why the state might be responsible. So we're gradually kind of honing in. Makaratsis, which was about a police shooting of someone in a car driving through Athens, and he was stopped by a hail of bullets. And that was really about that there must be a legal apparatus, there must be a legal framework to protect us. And in Makaratsis, the problem was that the laws went back to, I think, even the Second World War in Greece at that time. The laws regulating the way in which the police use firearms was so old, it was so outdated, and it wasn't sufficiently, it didn't include issues like proportionality, very, very old. But you've got to have, remember that first instance, protected by law. So it means you've got to have a sort of legal system, a set of laws that are coherent and that are sufficient. Okay, that's what Makaratsis is primarily about. And then this slide that Alice took you through is also really, really important in relation to people in custody. And this is absolutely fundamental. And in my role in the Harris Review, I find that this principle isn't always understood sufficiently, particularly within the health context in this country. People are sometimes detained in the criminal justice context. They're detained because they're suspected of an offence or they've been committed an offence. But also, people with mental health problems may be detained because they need to be protected. They're detained for health reasons. They need to be protected themselves, and they possibly need to the rest of us need protected from them. And so, as you know, you can be detained in psychiatric hospitals, but it's for health reasons primarily. Now, but in that context, what I find is not understood is that the human rights obligations are the same, whether you're detained in the criminal justice system, in the police cell or in the prison, or you're detained in a psychiatric hospital. The obligations on the state to look after you, protect you, are the same because you're detained by the state. And I find in practice that the people in the health field don't really always understand that as well as they should do. They think, well, we're looking after these people, this stuff doesn't apply, but it does. And one of the very, very important human rights principles that Az has already talked to you about is the burden of proof. And that because you're detained, the state have a particular obligation to look after you, but also they have to prove to the court what happened, or they have to establish to the court's satisfaction what happened. If they can't, then the state will be found liable. So the burden is not ordinarily. The burden is on those making a claim about something. If the families are making a claim that something's happened, the burden in human rights cases is on us, is on you to establish your case. That switches in a custody situation. The burden's on the state. Essentially, if someone goes into custody in a police station or goes into a prison or a psychiatric hospital and say with prison and police cells, they go in and they're healthy. If they're injured or even worse, they're killed, then the state has to establish what happened. It has to provide a plausible explanation about what happened. And if it doesn't, the state will be responsible. So the burden's on the state. And that in principle, in part, reflects the practical realities. Imagine if your relative is in custody somewhere and suddenly you're phoned up and you're told that they've died, how on earth can you find out what's happened? Because they're in custody, it's the state that's been responsible, and it's the state that is able to then has an obligation to gather information and also retain information and collect information in order to establish what happened. So this is very important burden of proof issue that comes from cases like Salman in Turkey there. So this, if you like, a summary slide, underlining the point that there is this positive obligation, and it's something I'm not talking today about preventive operational measures as such, but a positive obligation can mean all sorts of different things. It certainly is relevant to protection of individuals in custody. It's also right to say that the there may be positive obligations, but what that means has to be very carefully looked at, and the court won't impose unrealistic burdens. Just in passing, you've already talked about Osman. Osman, the case, do you remember the case of the schoolboy and the teacher who became obsessed with him, and there were various threats over a period of time, and the police were told about this, and in the end, the teacher shot dead Osman's father and shot Osman and injured him. She killed the father, injured the boy. And that established this, what is known as the Osman principle, again about positive obligations. In what circumstances does the state need to take steps to protect someone, prevent an obligation of their right to life? And that's the test. It wasn't violated in Osman itself, but that's the test. Where the state knows of, or ought to know, of a real and immediate risk to the life of an individual, and they fail to take measures that they could have done, which judge reasonably might have been expected to avoid that risk. So the two are elements to it. What do they know, or what should they have known, and what reasonably should they have done to take steps to prevent the risk. Now, if you think, just think about that in relation to someone who kills themselves. How would you apply the Osman test to someone who kills themselves in custody? Any thoughts? Yeah, go on.
If the state knew that the person was suicidal, had mental problems, and so they should have either detained them in a psychiatric unit, or just keep a vigilant watch on them. Right. Okay. Absolutely. So that's where. So we've got now from Article 2 and that very broad statement, that first sentence about protecting the right to life in law, through the application of cases to the Osman test, and this is a very different circumstances where someone was under threat, a pupil under threat from a teacher, and the question there was whether the police should have acted to stop the threat. But you've just explained that also, and you're right, is that principle can be applied even to someone who is in such a state that they attempt or they do kill themselves in prison, because it's this test that applies. What did the state know? What should they have known? And then the second element is, what should they have done? What reasonably should they have done? And we'll come on to again to talk practically about that in the prison context in a moment. And you've also had a couple of cases referred to that are very, very relevant. The Edwards case, and then Keenan, and maybe even one or two others. So just to remind you again, this was a you can see it's a European court case against the UK. So it's a European court case, and so this is not a self-inflicted death. This is a case of someone who was attacked by a cellmate and died. So what was the state's failing there? Can you remember Edwards? What's the primary failings in Edwards?
I think they failed to establish that the accused had mental conditions in that case. The person who stabbed on the victim. Yeah, well, I think they've taken precautionary measures. Yeah, yes. I mean, So the authorities did know that RL, this Linford, was in. They did know about his psychiatric condition, and yet he was put in the same cell with Christopher Edwards, who also had a different, but also had a psychiatric condition, and the result of which was this brutal attack. So one of the huge issues that is still very, very problematic, it was partly about the failure of different authorities to pass on information that they had. And this is still, if you look at cases as they're being reported almost every week in
this country, there are still problems about that. And I'm not saying it's an easy problem to solve, but you can imagine that you've got a GP, you've got a health authority, you've got the police, you've got prison, different prison bodies, you've got the courts, you've got the prosecution, you've got all sorts of different bodies that may have different forms of information about individuals. So the state is on notice, the state has knowledge of someone, yet if it doesn't pass it on as people move through the system, from arrest with the police, through to in the prison service, if that's where they go, if the information isn't passed on from the health services into the prison, when someone comes into prison, then you've got this real danger that things are missed. Okay, and I mean, if you look at the profile of people in prison, our mental health understanding is getting better and better, but it's very, very clear now that there's a very high proportion of people with mental health problems who are in prison. And you can break that down into different causes and the different ways in which their mental health problems present themselves, and therefore they create different risks. But so our knowledge is much better than it used to be, but it means, I think, that we also have a corresponding greater obligation to take steps to deal with those risks as our understanding is greater. So Edwards illustrates that real problem, that is still a huge problem. And Keenan is directly on point because Keenan is about the suicide. Another European court case, Keenan against the UK from 2001. Now they applied the Osmond test and found no violation, but they applied that test. It's very clear that the test does apply to a suicide, a self-inflicted death. But on the basis of the facts of the case, the court was satisfied that the prison authorities had done all that they could be reasonably expected to have done. They were aware that they did what they should have done, so there was no violation in that case. But it's an important case because it confirms the application of these principles even in sort of self-inflicted deaths, cases of suicide. But there was a separate violation of Article 3. Now, I think the last set of slides I wanted just to look at was, before we go on to talk a little bit more about the situation in prisons, is the question of investigations. So what we've been looking at so far is positive obligations under Article 2 to prevent loss of life or prevent a threat to loss of life. So it's a positive obligation to take steps to protect someone, isn't it? Okay. Now, there's a separate, entirely separate positive obligation, which is to investigate deaths. So you've got two, obviously connected, but they are separate requirements. And again, it's a positive obligation that if you're not going to put the Article 2 slide back up, but remember the very first slide that had Article 2, positive obligations simply come from that first sentence, the duty to protect in law. But it includes, we know from the case law, as well as this obligation to protect, a separate obligation to investigate. So in the situations we're talking about today, there will be an obligation, clear obligation in the state to investigate what happens, whether or not, regardless of whether or not it's clear or not that the state actually was at fault and in some way caused or contributed to the death. So clearly, the duty to investigate will arise when the state has caused the death or is responsible in some way for it, but also even when it's not. So there has to be effective investigation, even when the state's not kind of in the dock, as it were, for the initial death. And again, there's quite a lot of case law on this, some of which you've looked at. But I wanted to, let's go back, just ask you, how do you define an effective investigation? There are a series of requirements that are actually on the next couple of slides, but what are the elements of investigation in order for them to comply with Article 2? What kind of investigation must it be? Can you remember any of the principles from last week? perhaps you can just think of them from your use some logic and think through. If you were setting up a system that requires investigations of these cases, what would you say? How would you describe investigations to be in terms of principles? Yeah.
There was a violation in the procedure.
In the procedure, okay. Yeah.
They're conducting basically.
Can you give me an example? Maybe?
If they were in prison,
yeah,
and they have certain rules they need to follow,
yeah,
and there was a violation in that.
okay, yeah. So there would be. Okay. So I think that's true. There would be some rules set out, and you expect public authorities to comply with those rules. I think that certainly would be an important part of the investigation, absolutely. What about other principles that should be applied? How do you define an investigation?
I was thinking about basically the part that's going to be set to investigate. You have to be totally apart from the officers there.
Right.
Don't be biased.
Exactly. Okay. Right. So
be independent.
Independence.
Yeah.
Exactly. Independence. So as you said, totally apart from those that are investigating.
Yeah.
Absolutely. So independence. That's a key principle. So if you've got an incident with the police, you obviously can't have police officers from the same police force investigating, or if you do, that creates a potential problem. It doesn't necessarily mean they are biased, does it? You can have someone who would be trying to do a fair job, but the problem is that it creates an objective appearance that they may not be biased. That in itself is a problem. So you can't have people from the same institution investigating themselves. This comes up in the prison context sometimes, where if you've got, I don't know if you know, but the healthcare in prison is now, the principles are that the healthcare that people have in prison should be at the same standard as those of us in the community. That's the principle. So you've got all sorts of ways in which healthcare is provided into prisons by the local health authorities, sometimes by private entities and so on. Now there's a problem if there's a death in custody. We have to be very careful that the people who do the clinical investigation, so the medical experts who go in and investigate, have to be independent from those who are providing health care for the prison. So there has to, on the same basis, they have to be independent. So there's sort of this idea of separateness. Okay, so independence is the first principle. What else?
It has to be prompt.
It has to be prompt. Well, just say prompt. Yeah, that's a key one. So timing is absolutely critical. Why is that important, do you think?
To ensure that the evidence that they collect is valid.
Yes.
Rather because
yes.
with time
yes.
it can be quite distorted.
Yes, absolutely.
Because a recollection of what happened may not be as accurate.
Yeah, absolutely. All that's absolutely right. So in any incident like this, what happens immediately is that this, effectively, you've seen it on TV. That we've all seen it. You have to effectively seal off the site so that you protect the evidence, preserve the evidence that's there. But then you have to go and do the rest of the work in terms of gathering evidence, which might be interviewing people, it might be gathering documentary evidence, medical documents you need to know the state of the person's health and so on. So timing is crucial, both in terms of starting an investigation and then finishing it. And again, timing is a big issue for the investigation of deaths in this country. I mean, some of this may be surprising to you or not, I don't know, but the issue of timing is really important in practice. Do you know if there's a death in a prison, what is do you know anything about the investigation process? What happens? There's a death in the prison. Who investigates and what's the process? Do you know? Yeah.
Is it the IPCC?
That's actually. Do you know what that stands for?
The Independent Police Complaints.
Yeah. So they investigate police incidents, actually not prisons.
Oh.
They're just police. Yeah. Now there's a body that's equivalent to that. Does prisons? Do you know what
Prisons and probation on books.
That's it. Well done.
There's actually an article in the paper now of somebody who's just died in prison.
Oh, really? Okay. Okay. Well, that's right. Well, there we are. The PPO, the Prisons and Probation Ombudsman, is the equivalent to the IPCC that does the police. and their job is the immediate investigation. And the PPO was set up in order to deal with the point that you raised, that they're independent. They're independent investigators. The PPO have their own investigators. So they go in and they will carry out investigation, including a medical investigation, and they will commission medical experts if that's relevant to look at the case. So that's one part of it, and they will get on with it early on. What else happens in relation to death in custody later on? There's a sort of more of a judicial process. Do you know what that is? That's the inquest. Does that ring a bell? There's an inquest in which a coroner will investigate. It's like it is a judicial process in order to decide how and in what circumstances the person died. So those are the two main processes, and they are intended to comply with this Article 2 obligation to carry out an effective investigation. So principally there are two things: the PPO, and the PPO has a very extensive website that you can have a look at. All their reports are published, so you can see from the website the sort of reports that they will write and how they do it, what they do and how they do it. And then there's an inquest, and the inquest coroner will, before a jury, will hear evidence, and people are represented. So the authorities will be represented, the prison will be represented, the family may be represented. That's an issue we'll come on to. Health authority may be represented, so whatever's relevant. There is a process, and there will be a finding as to how and in what circumstances the person died. So those are the two main methods of investigation, and they are intended to comply with the positive obligation to investigate under Article 2, and they're intended to deal with this issue of timing, amongst other things. But that's still a problem in this country. There is still a problem. In fact, it can be caused by both the PPO and the inquest system. One of the things that the PPO is still rather slow at is getting a medical investigation up and running. They have to commission outside experts, and that process takes too long. That's one of the problems. The other problem is inquests. Inquests are even longer. Inquests are often held several years after the death, and that's partly because they've been waiting for the PPO to investigate, and sometimes for other reasons. Sometimes they have a backlog. There are various reasons. So can you imagine being a relative of someone who's died in prison? It's not clear why and how they died. You have to wait 3 years until the inquest calls in witnesses, hears the evidence, and you get some sort of decision about how they did it. Can you imagine having to wait 3 years? I mean, it's unacceptable, I think, but that's the system we have, and it's problematic. And the issue, one of the legal issues, is does it comply with this, with the requirement to investigate sufficiently promptly? Okay, so independent promptly. What else? What are the other principles in terms of investigations, do you think? What else would you want if you were if it was your relative? What would you want? A written report. Okay. Yeah. So it's made. Yeah. So it's made public at the end. So that's So it has to be public and open. Yeah. Absolutely. Anything else? Yeah.
Whatever conclusion they come to, any recommendations, any changes in the way they might do things are brought forward and actually enforced.
Yes, that's absolutely critical, and that's absolutely right. And that also is still one of the big problems in practice here, because what happens? Coroners are there isn't really a national coroner system as such. I wouldn't describe it in that way. The coroners are all employed by their local authorities. Okay, they're independent judicial officers, so they act independently. There hasn't really been a proper way of making sure that what the coroner finds and what the coroner recommends is then properly followed up. Now, and that's one of the things that the Harris Review we've been looking at very, very closely. How do you, because when the coroner let's say a coroner here in Hendon makes a decision and says that there's been a problem in the local police station or prison, and comes to, writes up some reasons for that, publishes that, how do we know that actually it's not just a problem here, but it's also a problem in lots of other parts of England and Wales? How do we know that the rest of the prison estate is looking at that? And of course they should be. That's not what happens certainly routinely. That's one of the problems. You're absolutely right. How do you know that there's follow-up, there's implementation? One of the ways in which the law has changed recently, there is now a chief coroner. So you've got all these coroners that cover the whole of the country. There's now a new body called the chief coroner who's a High Court judge, Peter Thornton. And again, you can look up what obligations the chief coroner has. In part, the chief coroner's role is partly to bring things together, to make sure there's coherence and things are joined up. But we didn't have a chief coroner until very, very recently. So that would be an improvement. So what have we had in terms of investigations? We've had independence, we've had timeliness, we've had open to the public. There are a couple of others. I mean, one thing I was getting at, the last thing I was getting at was really that there should be family involvement. If it's your relative that's died, you want to be involved in the process. You don't want to be excluded. So you don't want to see investigation going on over there, and you can't get in. You're excluded from it. So you need to be involved. What that means may depend on particular circumstances. And finally, and most sort of fundamentally, it has to be an effective investigation. I think that's perhaps what a number of you were implying, if not directly. It's so obvious, isn't it? But it has to be effective. Going slightly off-piste for a moment, as a human rights lawyer, a lot of my work has been in places like Turkey and Russia, where endlessly there are lots of cases where, very serious cases of killings and so on, where the state then doesn't investigate, or it carries out some kind of investigation, but it's ineffective. It's so ineffective. Very, very basic failings. They don't preserve the evidence at sea. They don't go and find out who the obvious witnesses are and take statements from them, the sort of thing that any reasonable person would do. Very, very basic requirements. So that question of effectiveness, it has to be effective investigation. Do the things that should be done in terms of preserving evidence and obtaining evidence. Primarily that's what it means. It's an obvious thing, but it's one of the key things. Independence, timeliness, effectiveness, participation of the families, involvement of families, and then it should be open to the public, so that the media can report about it, so that we all know the case you just referred to. We wouldn't know about it unless the media were there telling us about it. And if we were particularly interested, we can go and find out about it. So open justice. Okay. So all of those principles, all of that comes back to, go back to that first slide, that first sentence in Article 2 that talks about protection of right to life. There's no mention there, is there, of the duty to investigate. It all comes from the way in which Article 2 has been interpreted through the courts and cases like Jordan, which is a case from Northern Ireland, and some of the cases in custody. So there we are. There's the summary slide of these requirements: effectiveness, independence, promptness, accessibility to the family, public scrutiny. Those are the five principles. Now I want to just talk a little bit more about the Harris Review and the particular context. Slides to that. These are some stats from the Harris Review, just to, again, to a little bit of context. We're talking about deaths in custody in England and Wales. I don't know if I'd asked you how many people do you think die in custody every year, that's the number. It's very difficult to know. But so 549 in 2012. I think we have got figures for more recently now, but these are the figures haven't changed hugely. I've got a table I'll show you in a minute about comparing across institutions. So this tells you 549 in 2012, people died in custody somewhere, and it just sets out the different contexts of the different types of custody, and it's primarily, and this may or may not be surprising to you, but it's mental inpatients, people in psychiatric hospitals and so on. Huge numbers, 337. Now, of course, this raises the question, of course, a number of those cases would have died of their natural cause deaths. So we're not saying that there's anything necessarily problematic in terms of the state's involvement or responsibility. And that's one of the key areas. One has to work out how many of these are from natural causes. And I think the figures are, so about two-thirds of these were natural cause deaths. So that puts a little bit into context. So you've got 549 deaths altogether, but roughly two-thirds, 368 were natural causes. So we're not saying there's any responsibility of the state necessarily in those cases. And then after mental health patients, you've got prison. 192 people died in prison in 2012, and much lower numbers in police cells, 10 in approved premises, probation services, immigration detention centres, just 1, and these are secure training centres and secure children's homes. So secure training centres would be sort of adolescents, secure children's homes, younger children, and there haven't been any deaths, I'm pleased to say, in those for several years now. You've also got to put this in context of how many people there are in prison. What are the figures now? Something like 85,000 people in prison in this country. So you've also got to compare that with the number of people going through police cells. I don't have that figure on top of my head, but that's the state of, if you like, the state of numbers. Now, I just want to show you how the figures are changing over the years. I won't hit you with any more numbers after this. Here we are, it's this. So this is a table going back to 2000, just to show you how the numbers are changing. If at all, I'm going to just come over here. And you can start, again, it's the same, using the same, it's prisons and then police, mental health patients, same order. And you can see, increases in numbers of prison deaths from 2005. It depends how you, but of course, a reduction since 2004. You'd have to put that in context, you'd have to look at the numbers of people in prison, and broadly that's been increasing in recent years. Numbers of people dying in police custody is certainly lower in 2012, and probably lower in the late 2000s than it has been. You can see, again, height in 2004-39. Anyway, just to give you some context of the figures, and then I really wanted just to talk lastly about the practical realities of life in prison and how you protect people, what you have to do to protect people, what the problems are. I don't know, don't take this the wrong way, but have any of you been into prisons? And have any of you, for any reason, been into seeing what prisons are like? Because one of the things we've done in the Harris Review, we've done actually quite a lot of that in the last year, and it does give you, I think, an important context. And one of the things I just wanted to talk about finally is to talk about some of the areas of concern in this country about people in custody and about where the state is failing. And we've already talked about the issue of the failure of the state to provide, to pass on information. So when perhaps one body, perhaps the health service is aware that someone's has a particular condition, they get taken into custody, and then what's the liability of the state? If the prison should know what the health authority knows, but is the information being passed to the prison? Is the prison asking for it? Is it receiving it? That still is a real problem, a real issue. One of the things that the what the authorities want to change is that some of this is about technical capability, in that computer systems in one body don't talk to, are not connected with the computer system in another body. So at the moment, it's not possible if you receive mental health care within the community, that information isn't automatically transferable to healthcare staff in prisons. You think it'd be possible just to, with the flick of a button, send somebody's previous health records when they're detained in a police cell or in prison. But that's not possible. It's not technically possible yet, although people are working on that now to try and introduce that. You can see it's a kind of practical issue that once that's introduced and it's possible, the flick of the press of a button to get information, then it's going to be significantly improve the process. Because at the moment, you're perhaps reliant on either somebody faxing something or posting it, and there's all problems with delay and problems of even receiving it. One of the key areas, I've already mentioned this, is about mental health and our care for people with mental health problems. What's become very, very clear in recent years is that people who are detained in prison, a very high proportion of them have a whole load of what might be described as, or have been described as, imported vulnerabilities. They come in not just with mental health problems, but actually there are other issues in their life that make them very vulnerable, from things like that perhaps they've been in care, or they've suffered to a traumatic life instance like bereavements, or even brain injuries. They've had accidents, traffic accidents, and they've been injured, and that's affected them. Through to things like alcohol and drug addiction. You can imagine that when you come into prison for the first time, it's a very, very stressful, very, very difficult experience. And particularly if you're younger, you're perhaps less able to cope with that. And some of these things may explain why there's been this increase in self-inflicted deaths of young people, 18 to 24, in prisons in the last few years. There has been this increase. And so these are some of the things that we're looking at. What else, I'd just like to ask you, what else do you think, what other issues are there, in terms of actually in the prison? Any other issues that the authorities you think maybe an issue they should be looking at in terms of improving protection for people in prison? How do people actually, and this is very grim to talk about this on Friday afternoon, but how do people actually kill themselves? Do you know, usually, do you know?
Hang themselves?
Hang themselves, yeah. Hang themselves, yeah. And how do they hang themselves?
Bed sheets.
Bed sheets, yeah, it's usually
maybe
bed
thread
sheets.
from their clothes as well.
Sorry?
Thread from their clothes.
Clothes and bed sheets, occasionally shoelaces, yeah. And how do they do it though?
They probably get some kind of exchange, underground exchange. I don't know.
No, they don't. How do they actually, using bed sheets or clothing or how do they actually
tie it between this?
And they hang it off something. Okay, that's the thing. They hang it. Where are they hanging it from?
Maybe a pipe on the top of a bar.
Sometimes it's pipes. Sometimes it's windows. It's bars on windows. Yeah. It's still, that's the most common. Now, one of the things that, of course, the authorities have been trying to do is create safer cells. You can probably never say we can create perfectly safe cells, so they're safer cells, they're safer. And the idea behind that is to reduce the chances of someone killing themselves by finding a ligature point, which is usually bars on windows. It's sometimes pipes. The other thing they do is people use light fittings, and they burn holes in the structure, and you still use something that really shouldn't be weight bearing, but they use that. So it's very difficult to rule everything out altogether. But in terms of human rights law, again, you can see it creates obligations, because once we know that bars on prison cells are used as ligature points, then what do we need to do? We need to make sure that they're not accessible. And of course, what you usually see in prisons is they need to be bars, but they'll be boxed away
through perspex or something. So that, and there'll still be there'll be a grid with the air comes through, and there'll be bars, but they'll be boxed away so you can't get access to them. Safer cells, so the physical environment's very important. But what you hear that even then is that people will burn through the perspex and still get a ligature point. It's very, very difficult. People are so, in some cases, in such a state that it seems very, very difficult to rule out any possibility. But that's one issue. There's an obligation on the prison authorities and the Ministry of Justice to try and look at that across prison estate. What other issues are there? What other things in terms of protecting people in custody? Do you think?
Maybe even from other prisoners, there's possible contacts made.
Yeah.
Cause them to get what they need to kill themselves. In
Yeah.
that possible scenario.
Yeah. So that's
Whether it's
means.
you
Yeah.
mentioned shoelaces.
Yeah.
Possibly, if they had contact with another prisoner.
Yeah.
And they got shoelaces, whether it's theirs or
Yeah.
whichever
Sure.
reason.
The other issue that I thought you were going to say was that actually there's an issue
Yeah.
of sorry.
Sharing a cell with someone who's like racist or something.
Sharing cell, that's yes. So the Mubarak case is an example of that. Yeah, absolutely. I thought what you were going to address was bullying, and because that's another big issue in prisons is of course the psychological impact of people, especially if you're young, you're vulnerable for the reasons I've described. You've got perhaps mental health problems. You've got learning disabilities, learning difficulties, and you're the target of gangs and bullying. Perhaps you can see in a closed environment, you can see how, perhaps you can start to see how awful that can be. What were you going to say?
I was going to say, people like paedophiles or religious fanatics, they are often targeted as well.
Yeah, so yeah, that's absolutely right. So the state in those situations would have an obligation to protect people. Sometimes they will be put in segregation for their own safety. One of the things that raises, if you put people in segregation, well, it's also an issue across for everyone, is the amount of time people spend in their cells. And what's happened in recent years is, in this time of austerity that we live in, and the government is, rightly or wrongly, depending on what you believe politically perhaps, is reducing public expenditure. The number of prison staff have been very significantly reduced in recent years. What that means is that people are allowed out of their cells less and less because they haven't got staff available to as it were, to police it. So what it means in some situations is that people are spending long hours in their cells. They're not given purposeful activity. They should be given work, they should be given classes to do, which are theoretically available. They are available in lots of situations, but it seems to be an increasing problem of people being banged up sometimes for 23 hours a day, out of 24. Can you imagine being in that context of a prison, having your sentences, and you're banged up, and you can't get access to purposeful activity, so you're left on your own with your own thoughts. It seems to me obvious that that's going to create more and more problems. So the staffing issue is actually incredibly important because it affects the ability of people to engage, to have what they call association, to meet other prisoners, to meet other people in prison. There are quite a lot of people that come in to provide different services in prisons, and sometimes those services are not accessible because of the staffing problem. Anything else?
I was thinking, I don't know, I was thinking maybe for the psychological part, because well, I know people there in prison, and I have some friends in prison, and I think the first I think the couple months that you just go to prison, maybe the hardest part is the contact that you lose with your family.
Yes, yes.
And I think it's very strict the contact that you can have and the times.
Yes.
And it's not even sometimes you don't have every week even. So
yes.
So I think
that's absolutely right. I think absolutely right. Family contact is really important, and again, from what we've been hearing as part of the Harris reviews, that it's quite problematic. It's quite difficult if families on the outside have got concerns. Perhaps they've had a letter from someone. They're very worried.
this person is, they're depressed or whatever's happening. How do they inform the prison? That seems to be very, very unclear. They'll try and ring into the prison. What we hear time and time again is that it's not clear who they should speak to in the prison in order to get a message to someone that they're worried about their son or whoever it is. What happens in practice is that often they'll get put through to the chaplain or the equivalent, and there'll be a prison chaplain or people offering services from different religions, and it's often they pick those up and they'll often deal with them, but it's all informal. It's not. There's no system. And for the one of the great things that we hear for prisoners themselves is if they don't have that, if their visits are banned for any reason or restricted, then it has an appalling effect on them. And because of the uncertainty, the contact is so important.
Because the biggest support they have once they're inside is only their family they have outside.
Yes, absolutely.
So supporting mentally.
One of the ways in which the prison services have been trying to support prisoners in quite recent years is to have a personal officer, someone in the prison who is assigned to me as a prisoner. I have a personal officer who I can go and speak to, who will kind of keep an eye out. Now that, from what we hear, that's been actually quite effective, primarily because it's simple. It's someone who has the time and the energy and the interest to stop and come and talk to you when you're at a low ebb.
Just listen.
To listen and to be there. And in fact, what seems to have happened is that prison officers scheme has disappeared in many prisons, again because of the staffing issue. The staff do not have the time to offer the time of day to someone because they're too busy, because there's too few of them and they're having to do other things. So that simple sort of human element of stopping and talking and checking in on people isn't happening, and that also seems to be a problem that is also one of the issues that needs to be dealt with. We all, for young people particularly, the evidence is that they need some sort of significant adult in their lives, whether that's in the family or if not in an institution, a significant adult who will provide that sort of contact that they need. It's particularly, the evidence suggests that young people do need that because they have less life insurance.
I want to be helpful to point out, or to try and explore, there's all these kind of background conditions to do with not enough staffing, so people being incarcerated for longer hours, and those kind of structural issues. I suppose one question people might be interested in is when does the Article 2 obligation kick in, if you like? You've got the sort of background conditions, but then you've got these more operational questions that regards a particular prison and a particular circumstance. So when do the general failings, if you like, start to turn into a breach of Article 2, or what kind of...
In terms of resulting in loss of life or investigations, or...?
In loss of life initially.
Loss of life. Well, I mean, it could be at any stage, couldn't it? I think, and it could be a cumulative process. There aren't so many cases that deal with that issue. There are examples of relatively few, but in terms of someone taking their own life. But it seems to me it could be a whole series of accumulated situations. I mean, that the evidence suggests that it's not. This is not sort of. There's not one factor that is. Usually, it's not one factor. It's a combination of the factors that we've been discussing. So, in terms of a hard legal obligation, I think you could look at all of these factors over time.
So it means, I think, when you're looking at the cases for your coursework, one of the key things is to look at so much of it is in the detail of the situation, isn't it? The steps that led up to the loss of life, whether it's self-inflicted or inflicted by somebody else.
Absolutely.
And the whole, possible catalogue of failing to do with information. The person's, what was known about the person's state, other environmental factors. There could be all sorts of, as you say, cumulative things which would all be taken into account in terms of the state's obligation.
Yes, absolutely, Well, are there, do you have any questions or comments about what I've said? Is there anything you wanted to ask me more about? Yes?
When these prisoners are taking their life, is there no one watching them? I know they're short of staff, but there's cameras, and like I watch 24 Hours in Custody, the TV program, and on there have been a few people who tried to, you know, kill themselves.
Yes.
And the police officers, you see the police officers rushing to the cell
Yes.
to try and stop them.
Yeah.
So,
Yeah. So they can be closely watched, and again that depends on, there is a process, the ACT process, which is an acronym that's ACCT, but it's CCT. It basically means that the prison is aware that someone's at risk of harming themselves. So that you go on to this ACT process, and that means that then you will be, depending on what you need, you will be watched much more carefully. And it may be that you are checked every hour or even every 10 minutes or constantly, depending on what your situation is. So you would be, so they would try and match those circumstances to the evidence they have about them, certainly. Cameras in cells, you don't have cameras in prison cells, you will much more commonly in police stations. But of course that raises a separate issue about, is it right, is it acceptable to have cameras in cells? Someone has a 5-year sentence. Would you want to trade off your privacy rights with a camera in your cell all that time against the risk of you doing something to yourself and the state's positive obligations? So there's a trade-off. So we don't have, for those reasons, we don't have cameras in cells. The process is that or in prison cells. The process is that we have a system that ensures that prison officers should be observing where that's needed. There is this potential conflict between privacy and the state's obligations that explained. Anything else? Anything else you wanted to come back to me on?
I had a question there, I'll let it go, but in terms of the failure to pass information, there's any defense, let's say, for the police, in terms, I don't know if there's any possible excuse, or if it's something they so straightforward that there's no way they can say, no, we tried to do this and this, but...
Well, there may be reasons why an individual body like that, in practice, didn't get the information. So they may be able to say fairly, maybe a fair point, that we asked for the health authority for their health records, but they didn't give it to us. In which case you can't say the police were at fault. But in terms of looking at it more broadly, the state's still at fault if there was evidence within the system somewhere, and the evidence showed that somebody was at risk, they were at risk of self-harming or whatever it was. If that evidence isn't then made available and acted upon, the state is at fault generally. So in a sense, it's regardless of whether it's the police or the prison or the court or the health service. So
because it's kind of like you said, there's a failure to have a proper system to pass the message.
Yes. Yeah. Okay. Anyone else? Otherwise, I'll leave it there. Thank you very much. And,
thank you very much, Phil. Now, we've just had the coursework thrown at you today, so don't panic. It's not due till the end of April, so you've got a lot of time. And I will make sure that we have more time to discuss some of the more detailed, your scenario involving the IPCC, which Phil mentioned, which is the Independent Police Complaints Commission that will investigate death in police custody. And there has recently been a review that the IPCC has undertaken of its own work in relation to its compliance with Article 2. So we'll have a look at that in a future session to get some idea of what the IPCC as an independent investigator should be doing, and then you can see in your scenario how it matches up to the expected standard. But for now, thanks very much to Phil. Thank you also on behalf of our students and colleagues in Mauritius who will be watching this on a film soon. But for now, enjoy the weekend, and I'll see you on Monday.
Thank you very much.